Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States. God save the United States and this honorable court.
This is Hans von Spakovsky, and this is Court is Adjourned. We are rapidly moving into a very active election year, one that may be very controversial, in which we may see very vigorous fights all over the country as folks compete to get into Congress and into local offices also. Now, states usually do redistricting in the first 2 years after the census. But it's not that rare that states have occasionally, once again, done redistricting later in the decade. That particularly started happening in 2025, at the beginning of 2026, as states like Texas, California, Virginia, and other states started talking about and started implementing new redistricting plans in order to try to change the makeup of the U.S. House of Representatives, which has one of the smallest margins of difference between the Republicans and Democrats in U.S. history. All of those cases, all those redistricting, I should say, have ended up in court, in litigation, all kinds of claims being made about those redistricting plans being, for example, violations of the Voting Rights Act, unconstitutional, etc. The one thing people should realize about redistricting is that when states do redistricting in the first 2 years after the census, Americans have a highly mobile society, and those districts, which under Supreme Court precedent are supposed to be as equal in population as possible, certainly with regard to congressional districts, rapidly become distorted because the populations change in those districts. Now, here to give us an update on what exactly is going on with the redistricting, with the lawsuits that have been filed, is J. Christian Adams. He's the president and general counsel of the Public Interest Legal Foundation, which has been involved in much of this litigation. Public Interest Legal Foundation is a advocacy organization dedicated to securing election integrity throughout the country. He and I worked together, actually, the Department of Justice a number of years ago. He's a commissioner on the U.S. Commission on Civil Rights, and actually President Trump in the first term appointed him to a Presidential Advisory Commission on Election Integrity, and he also is the author of a very revealing book called Injustice: Exposing the Racial Agenda of the Obama Justice Department, which is well worth reading. So, Christian, thanks for coming today. It is a bit unusual what we've seen, right, with the redistricting process being initiated in so many different states. Texas went first. You know a little bit about the Texas case.
Oh, boy. Yes. We were representing Galveston County. This sort of set the dominoes falling. And to make a very long story short, very complicated story short, our case blew up what's called coalition districts. Coalition districts are when Black and Hispanic populations merge together to become plaintiffs to say, we want a congressional seat together, like they satisfy the requirements to be a majority. Well, that had been the law in the Fifth Circuit for 34 years. And in our case in Galveston, we represented Galveston, Public Interest Legal Foundation. We said, let's attack the coalition district as contrary to the Voting Rights Act. So we dropped that defense into the case. It was the law in the Fifth Circuit. We lost to the district court because that's the law. Well, we went to the Fifth Circuit on appeal. The Fifth Circuit panel, 3 judges panel, said, well, the law is the law. You're allowed to do this.
Right.
If you want to change the law, go to en banc, which means the entire Fifth Circuit, which we did. The Fifth Circuit reversed 34 years of jurisprudence and said Black and Hispanic populations can no longer combine to demand a congressional seat, to demand a legislative seat, to demand a school board seat, anything. And so it completely transformed the law in Texas, Louisiana, Mississippi.
Let's explain. I mean, the reason for that, and by the way, we should explain, Fifth Circuit was one of the few Court of Appeals circuits that actually said that these kind of coalition districts are protected under the Voting Rights Act. The reason they said was, look, the Voting Rights Act is supposed to protect racial groups from discrimination. When, for example, black voters and Hispanic voters get together, they're forming a political alliance, and political alliances are not protected by the Voting Rights Act. So it made perfect sense what they said, right?
It did. Now, the other side will tell you that they both suffered under Jim Crow together. They're like, brothers in arms kind of arguments. But the case all turned on an S, believe it or not. When Congress passed the Voting Rights Act in 1982, this is the 82 amendments, it protected a class of voter, C-L-A-S-S,
right,
singular. The other side was trying to argue that it's really classes that get together, the classes get together and demand a seat. That's what the whole case was about, was the text of the Voting Rights Act.
Yeah, but and we also know that's not true. For example, you and I had experience when we both worked at the Justice Department. There were large coalitions of black voters and large coalitions of Hispanic voters in Los Angeles, and they fought fiercely.
Yeah.
They did not vote for the same candidates. They did not have the same choice of who they wanted elected. So the idea that they were getting together because of their race just didn't work. So that case out of that county kind of blew up the whole congressional redistricting map in Texas, right? Because there were congressional districts that had been formed that were coalition districts.
Most
right?
were in
Yeah.
Dallas, Houston, places like that.
So that gave the Texas legislature the ability to redraw districts and to try to make them favor Republicans, not doing it on a racial basis, but trying to favor the election of Republicans, right?
It's interesting you mention ability. That's an important word. Texas had the choice to decouple these racial coalitions or leave them in place. There
Right.
was nothing necessarily against it. The Fifth Circuit did not say you have to get rid of this.
Right.
It
It just said it wasn't necessary.
Right. And that's a subtle difference, but an important one.
Yeah.
And the legislature chose to do it. Now, we should go back to California at some point because that's
Well,
a
that's
fascinating
next.
story.
California's next.
But what you said about Los Angeles is fascinating because
Right.
Hispanic population, many of it non-citizen,
right.
began to squeeze out black representation around Los Angeles in the 80s and 90s and 2000s, where black representatives were losing seats because non-citizen Hispanic population was being counted for the drawing of these maps.
Right.
So
the Texas case, they did a redistricting.
Right.
There was a federal judge federal judges who said, "Oh, you can't do this redistricting. It supposedly violates the Voting Rights Act." But that went up to the Supreme Court. The Supreme Court stayed it, right? So are the new districts that they drew in place for this upcoming election?
It's well, that's a Purcell question, and there's still a fight going on about the new districts. What's interesting, we had a second case in Texas that went to the Fifth Circuit that I argued in October, involving what is racial intent, what evidence is relevant to prove that Texas acted with a racial intent. And that case is called Jackson versus Tarrant County. We represented Tarrant County, and that went to the Fifth Circuit. And many of the same issues in the statewide redistricting are present in the Tarrant County case. And the courts hemmed in the evidence that can be used to show racial intent in Texas.
So there's no decision yet in
No.
that Tarrant County case?
Well, there is in Tarrant.
Right.
There is. The plaintiffs in Tarrant, after they lost in the Fifth Circuit, quickly raised a white flag and surrendered and dropped the case.
Okay.
So
then California said, well, we're reacting to what Texas has done, and describe just kind of quickly for folks what exactly happened in California.
oh my gosh, is this crazy? So the legislature, not liking what was going on in Texas, passed a law in California that said we're going to have a referendum in November, and we're going to attach a map that the DCC, Democratic Campaign Congressional Committee, drew and stuck it on the referendum.
Right.
Said this is the map. And it went on the ballot in November of last year?
Right.
5.
Yeah, 25.
And the voters passed it. But we're challenging it there.
Now that was, to me, unexpected, right? Because they didn't just have to pass potential new map. I mean, the legislatures normally could do that, but the whole reason they had a referendum right was because a number of years ago, again through the referendum process, the voters in the state approved transferring the power to redistricting from the legislature, which is a supermajority Democrat, to a supposedly independent redistricting commission. And what, this referendum overrode that independent redistricting commission?
I left that out of the storyline. You're right. So they had this independent redistricting commission in California that, frankly, the Republicans kind of wanted. I mean, it wasn't the greatest thing for them, but it was at least was something. And the referendum wiped it out. No more independent redistricting commission. We're going to use these maps. Mm-hmm. And so that's what happened in the election in November.
Now, that case also, the lawsuit was filed. It also went to the Supreme Court, but there was a different result from the Supreme Court, right?
So this is super tricky stuff, and I'll try to make it simple.
Okay.
There's multiple lawsuits. And the first one that got filed, the name is Tangipa, if you're keeping track, they lost at a preliminary injunction hearing, and it rocketed up to the Supreme Court. The Supreme Court didn't do anything with it and basically sent it back.
Okay.
Yeah, and so that case is still going on, and just this week, that case, Tangipa, has been consolidated with my case, Noise. The two of them been collapsed together, and it's going to plod through the regular trial process now.
Now, if I recall correctly, but there are different claims being made. The first lawsuit was making claims, was it under the 14th Amendment,
right.
Equal protection, et cetera, but the lawsuit you filed is under the 15th Amendment. Now, what's for ordinary laymen and non-lawyers, actually for a lot of lawyers who don't seem to understand this, what's the difference between those two claims when you claim under the 14th versus the 15th Amendment?
Huge difference between the two cases. Now, you can guess which one was passed first after the Civil War, 14th Amendment.
Right.
And that's the Equal Protection Clause. And then the second one was passed a few years later. That's the 15th Amendment, which says you can't discriminate on the basis of race or use race as a tool in crafting election laws. It's absolutely prohibited. But the 14th Amendment hurdle for a plaintiff is like this high. You have to show that race predominated, there wasn't a compelling state interest, compliance with the Voting Rights Act was not a compelling state interest, all these hurdles. The 15th Amendment is much simpler. I've won cases under the 15th Amendment where you just have to show race was involved.
Right.
Race was a player on the stage. Under the 14th Amendment, race had to be the lead actor on stage. Under the 15th Amendment, they just had to have a bit part. And it's both of them are illegal in that case. So our case is brought under the 15th Amendment. The first case is largely the 14th Amendment, largely the 14th Amendment.
So this, I mean, we're already in the end of March, beginning of April, and yet these cases in Texas and California are still being litigated?
Yeah, oh yeah. As a matter of fact, they're going to be litigated heavily for a while, I think. We actually just got ordered to file a consolidated complaint in our California case, which I called Noise. Mm-hmm. It's Noyes, not Noise. And we have to file a consolidated complaint with the other plaintiffs. So,
I mean, if you get a result, even if you get a result, I mean, let's assume for just a second that in the California case, you got a judgment saying, well, these new maps that were drawn by the legislature violate the 15th Amendment. Would it be then too late for that judgment to go into effect if it's later in the year before the November election?
For the election in 2030, no, but your question is the current election.
Right.
Probably it is, but that doesn't mean you don't try. Right? You have to push it. This is this case that I'm talking about, Noise, is the only way that these maps will not survive. There's no other way to stop it. This is it. So we have to try.
Now, the same thing has happened in Virginia, right? The Virginia legislature, I mean, Virginia basically had a complete change of control by political parties. The Democrats from the last election completely took over the statewide offices, both houses of the legislature. And they also kind of followed what California had done. They had also put in place an independent redistricting commission, and they've overridden it to come up with new maps that would basically get rid of almost all of the Republican congressional districts. But that referendum's up for an election in Virginia, right?
Which is happening now. And by the way, Virginia is a good illustration. None of this is about principle. It's about power. Right. And the Democrats put this plan in Virginia because they thought it would limit Republican power years ago, this independent redistricting commission, which you know is not independent. They never are.
Right.
They're never independent. And so Virginia had this commission, and as soon as they could attain more power for the Democrats, it's no longer about principle, no longer about rigging elections, they passed this new rule to make it basically an 11-to-1 congressional delegation. They're taking populations in Alexandria, which is very blue, and running the congressional district down the Potomac the whole way through the northern neck, which you know is very red.
Right.
But there's more blue than red, and so it becomes a congressional district. So it disenfranchises, in the sense, political disenfranchisement, all of these rural populations by anchoring them into Northern Virginia as like it's a weight on the district of population.
Do you think any of these districts that they've drawn are they potential violations of the Reno versus Shaw case? And what we're talking about is that I think it was North Carolina, right? Years ago, when Janet Reno was the Attorney General, they put together a district to connect two areas of the state that were basically heavily populated by black voters, and they connected it with a interstate road. It looked like a
Mr. Sparky.
It looked like a dumbbell, right?
Yeah.
And the Supreme Court in that case said that if race predominates the drawing of a district, that's a violation of the one person, one vote standard, equal protection. Are any of the districts in Virginia, do they look like that?
Well, what's interesting is Virginia seemed to preserve, this map in Virginia seemed to preserve the two majority-minority districts kind of intact as far as ability to elect. North Carolina, some people refer to as Mr. Sparky, who was a character in utility ads in the 50s and 60s with like arms and jagged stuff. The Mr. Sparky map drawing in Virginia is political. It's not racial. It's like Arlington goes to the northern neck, to Reedville. The next one over goes down through Fredericksburg, in south. So it's using urban population to wreck the ability of rural population to elect their candidates of choice, which is far more legal, if not completely illegal, under Rucho versus Common Cause, another Supreme Court case, allows them to use partisan data to draw the map.
Yeah, what we're talking about here is a couple of years ago, actually the Democratic Party sued, I think it was Wisconsin, trying to claim that partisan gerrymandering, when you simply draw lines to give a benefit to your political party, that somehow was unconstitutional, and the Supreme Court said, that's a political question. We're not going to get into that.
For good reason. The founders wanted control of elections with the states and the people who are closest to power, meaning your local House leadership, your local Senate. They wanted control crammed down. So if you didn't like it, you could change it. Right? That was the whole purpose of why the founders designed the country this way. So the argument in Rucho is, you don't like what happened in Wisconsin, you don't like what happened in Virginia, go elect a different legislature. That's the remedy.
Right. Now, there is another big redistricting case pending before the Supreme Court. Now, I do have to say, orders are being issued now almost every other day from the Supreme Court. So by the time we broadcast this podcast, it's possible that the Supreme Court may have issued a decision, but that's called Louisiana versus Calais. Tell folks about what that case is about and why it's so important to the whole redistricting process.
Yeah, so here we have a situation in Louisiana where the Louisiana legislators passed a congressional map to create a second black district, and they said so. They said, we're creating a racial district. On the floor of the legislature, questions, for example, were asked of the sponsors by other members, why are we doing this? And the answer was, because we're trying to create a black district. Like, all this naked racialism on the floor.
Now, if I recall correctly, was it Louisiana has six congressional seats? They had one seat that they thought was necessary
Correct.
under the Voting Rights Act. There was a majority, what they call a majority-minority district. The black voters are majority, so they can elect their candidate of choice, but somehow they were under the impression that the Voting Rights Act required them to draw up a second district.
The impression was a preliminary injunction by a federal judge. And
so a federal judge is telling them, "Oh, you have to draft up and the lines for a second district based on race."
Well, based on the performance of the Jingles test, they could draw it. Now it was a little Mr. Sparky, and there's a preliminary injunction. The federal court ruled, you have to draw a second black district. Now, any lawyer knows a PI is not the same as a final judgment.
Right.
But what happened was certain people in Louisiana took that PI and went to the legislature and said, we have to do this. Well, that's wrong. You don't have to do it until it's a final judgment.
Okay. All right, but they did it.
They did it based on that PI.
And then they got sued again?
By different people, right? And that went to a 3-judge panel.
Right.
And the 3-judge panel heard all this evidence about what happened in the legislature. Now, here's a little secret. If the legislators on the floor had said in Baton Rouge, we have to do this to comply with the Voting Rights Act, they would have been in a stronger position. We have to do this as a remedy, stronger position. Instead, they said we have to do this for blacks. They literally use race in their open statements. That kills them. And you can't enact something for a racial reason. That's the 15th Amendment.
Right.
You can enact something for a remedial purpose after a final judgment. See, that's why this case. Can we bet on the opinion? Louisiana's going to lose. The plaintiffs challenging these maps are going to win.
Yeah, but this case kind of really illustrates the how hard it is for legislatures to draw the line between, on the one hand, they'll have the NAACP and others suing them saying, you didn't consider race enough when you were redistricting. But then if they go overboard and consider race too much, they'll get sued again by people saying, well, you violated the Equal Protection clause, and drawing that line is very difficult, right? Particularly because, as we see in this case, different federal judges can look at the same set of facts and have totally different conclusions.
This is important, what we're talking about. It's very hard to do what you suggest, but it's not impossible.
Right.
And the way you do it is with the Jingles framework and a real court opinion in a final judgment.
Now, you keep mentioning Jingles. For non-lawyers, what we're talking about is in 1982 when Congress amended the Voting Rights Act. There was, of course, immediately a lawsuit filed, and in a case called Thornton versus Jingles?
Jingles v. Thornburg.
Jingles v. Thornburg, right. The Supreme Court set out this whole set of standards and this whole test for how to apply the Voting Rights Act and to figure out whether legislatures have acted to violate the law, right?
Yeah, and let's not forget who passed and signed the 82 amendments, right? There's a story. Republican Senate, Strom Thurmond.
Yeah.
President Reagan signed it. So this was not a wacky Biden era or Holder era idea. This came out of the Republican Party to a great degree.
Yeah, but the problem is these standards that they came out with were in 82. And from what I've observed, and I wonder what you think about this, the problem we've had really in the last decade, actually I think the last 2 decades, is the standards are so out of whack with what's been happening in this country that a lot of judges and the people who sue, they try to confuse or take political motivations and say, oh, these were racial motivations, therefore there's a violation of the Voting Rights Act. Basically, they're using the Voting Rights Act for political purposes, not to actually remedy real racial discrimination.
For sure, and we saw that at the voting section all the time. Like, let's make sure we elect Democrats where there aren't any. Look, there's
we're talking about the voting section inside the U.S. Department of Justice, which is supposed to represent the public and be nonpartisan. But what we saw of all the lawyers who worked there was that their chief interests seem to be ensuring that Democrats won elections, not to have a neutral enforcement of the Voting Rights
We
Act.
could do a whole show on the Kinston preclearance objection,
right.
but that's another story. Look, one of the standards you talk about under Jingles, one of them is called existence of racial appeals.
Right.
Now, racial appeals does not mean racist appeals. It's very important to understand. It could be things like, he's one of us. It could be putting your picture on a billboard when you're white. It could be putting your white picture on your billboard and the picture of your black opponent. That's considered a racial appeal under the law. The problem is, it's a one-way ratchet for plaintiff. If racial appeals exist, then plaintiff benefits from this Senate factor. It doesn't help a defendant.
Right.
So it's one we've argued in briefing in another case that the Supreme Court should take a second look at these Jingles Senate factors
and
to
basically,
reevaluate.
basically modernize them,
Right.
And not have them so out of date with practices that don't exist
And remember,
anymore.
this comes from the Senate report. This is not; these Senate factors and Jingles is not totally detached from the legislature, but it wasn't in the text of the statute. That's one of the interesting issues.
Right. So, any other redistricting cases that you've seen? I mean, there were other states that, for example, President Trump urged them to redistrict, but they didn't do it.
Indiana,
Yeah.
right?
Right.
Well, look, I'll tell you a really interesting redistricting matter that's bubbling is out of New York. A lot of states have enacted their own state versions of standards, state versions of Jingles.
Right.
And
Well, state
Voting
Voting Rights Act.
Right.
Right.
And what they've done is they've gone even further than Jingles, right? They basically said if you have a district, you don't have to have a compact racial population. They can be spread out, and you do set-aside seats. It's like something out of the New Zealand legislature for Maori. And states have gone this far.
Right.
And
I should say blue states.
well, that's true.
Yes.
It's Washington, Oregon, New York, Virginia actually has one, and so the conservative movement has not aggressively looked at this yet. Now, PILF has done so. We've looked at it. Some other people, like in Washington, that we both knew at DOJ, have Joel Ard, but there hasn't been an adequate focus on this issue.
Yeah, and this is something we should explain. A lot of people don't understand that the Voting Rights Act is race neutral. It protects any minority group in a particular jurisdiction if they're being discriminated against. So, in fact, you and another lawyer, a good friend of ours, actually won the first case that the Justice Department ever filed down in Mississippi, where white voters were actually a minority in a particular county, and they were being, I think the judge said, they were being blatantly discriminated against. But these versions of the laws that you're talking about that the states have put in, they're not race neutral. They're set up so that if you're, for example, black or Hispanic, if you're Asian, and you're discriminated against, you got a cause of action. But if you're white and you're discriminated against, you have no cause of action. I mean, that to me is just unbelievable.
That's why I think they violate the 15th Amendment, and there needs to be a real focus on this and how to undo this racialist state law. Oh, by the way, when you mention whites being discriminated against in Mississippi, that's when all the people on the left watching us roll their eyes, right?
Right.
They didn't read the case, the opinion,
Right.
where there's brazen racial discrimination. Not a popular case at the Justice Department when it was filed.
Oh, no. There were lawyers there, career lawyers, who refused to work on the case.
There were career lawyers there helping the other side.
Yeah. Well, that tells you a lot, unfortunately, about the voting section. Although people can learn more about that by reading your book.
Injustice.
Right.
14 years old now. No, 13.
Yeah, but still very much relevant to the way the Justice Department was run.
Right.
Well, Christian, I thank you for coming today. It's all been very, very interesting, and like I said, by the time this is broadcast, we may have gotten a decision in the Louisiana case, and it's going to be very interesting to see what the Supreme Court does. By the way, we should mention that I think it was Justice Alito just a couple of years ago complained about the fact that they get so many redistricting cases coming to the Supreme Court. So maybe that's been an incentive for them, hopefully, to come up with tighter standards so they don't get those cases. Now, as you know, I try to do a classic movie review that's related to the issue of the topic. we've been talking about. So today I am recommending State of the Union, which is a 1948 movie directed by Frank Capra. And everybody knows Frank Capra because of Mr. Smith Goes to Washington. But State of the Union is actually a very interesting movie when you look at events today. It's Spencer Tracy plays a rich business owner who is encouraged to run for president as a Republican nominee by his politically ambitious girlfriend who owns a newspaper. She wants him to win so that she can be the power behind the throne. If that sounds like Hillary Clinton, it's not. Anyway, the girlfriend's played by Angela Lansbury, and Spencer Tracy's estranged wife is played by actually Katharine Hepburn. The movie kind of illustrates, I think, the cynicism, backroom deals of politics, and Spencer Tracy's growing compromise of his principles in order to win the nomination. Technology has changed, but I think people watching this may see that politics hasn't changed that much since it. By the way, the movie was privately screened for President Harry Truman at the White House, and the story is that it actually helped convince him to run for re-election. This is Hans von Spakovsky, and this has been Court is Adjourned.
Loser. You and your mad ambition, catering to his conceit, dealing and double-dealing. You were going to make a big man of him, weren't you, Kay? You couldn't see that he was a big man. Well, you killed him. You've killed Grant Matthews. And he's a party to his own murder. Well, I won't be.